Now, I'll talk about right to privacy as a fundamental right of the citizens. The evolution of the right to privacy in India has been shaped through decades of judicial interpretation. In 1953, the early Supreme Court case challenging search warrants, the Supreme Court held that the Indian Constitution did not recognize privacy as a fundamental right. Then again, 1962, in a surveillance related case, the court, the majority opinion again rejected privacy as a fundamental right. However, a notable minority opinion argued that the Constitution does, in fact, protect privacy. In 1975, the Supreme Court acknowledged privacy as a common law right, though still not a constitutionally guaranteed right. In 1994, the Supreme Court, for the first time, linked the right to privacy with Article 21, that is, right to life and personal liberty. It affirmed privacy as implicit in Article 21, though not absolute. Then, the right to be forgotten allows individuals to request the removal of personal information from the internet, particularly from search engines, to protect their personal privacy and reputation. The first case in India to deal with the concept of the right to be forgotten was heard in the Gujarat High Court, where the petitioner prayed for the removal of a published judgment in which he had been acquitted. The court didn't per se recognize the right to be forgotten and disposed of the case as the petitioner had not been able to point out specific provisions of law that had been violated. Then the Karnataka High Court has also made references to the trend in the Western countries where they follow the right to be forgotten in sensitive cases. In the case of Shubhranshu Raut versus State of Odisha in November 23, 2020, the Odisha High Court emphasized the significance of the right to be forgotten, particularly in digital contexts involving personal and objectionable content. The case concerned the online circulation of offensive material about a woman. Although Indian law currently lacks explicit recognition of this right, the court urged the victim to seek appropriate remedies to safeguard her fundamental right to privacy, noting that the proposed data protection bill would likely include provisions for the right to be forgotten. In contrast, the Madras High Court on August 3, 2021, rejected a petition seeking redaction of the petitioner's name from a judgment. The petitioner acquitted in a criminal case argued for the removal of his name under the right to be forgotten. However, the court observed that no clear legal framework currently exists in India for such redaction and found it more prudent to wait for the enactment of the comprehensive data protection legislation before recognizing or enforcing such rights. Hence, the petition was dismissed. Now, I'll talk about Draft Digital Personal Data Protection Bill 2023. In pursuance of the developments in court towards Recognizing privacy as fundamental right, the Indian government has been in the process of introducing an extensive data protection law since 2018. So, four drafts of a proposed standalone data privacy legislation have been released by the government. The current and the latest draft of the proposed framework, that is, Draft Digital Personal Data Protection Bill 2022, was released on November 18, 2022, for public consultation, inviting comments for stakeholders and general public until January 2023. The proposed law prescribes compliances for collection, storage, handling, and transfers of personal data. It applies to the process of digital personal data in India, where the personal data is collected from the data principal online and collected offline and subsequently digitized. It also imposes a soft data localization requirement for all personal data. Now, talking about CERT, in Directions for Cybersecurity Incident Response (CERTs), Cybersecurity Incident Response on April 28, 2022, the Indian Computer Emergency Response Team, the designated national agency under the Information Technology Act 2000 for handling cybersecurity incidents, issued a set of mandatory directions. These directions specify that certain types of cybersecurity incidents must be reported within 6 hours of detection or being informed of such incidents. The obligation applies to service providers, intermediaries, data centers, corporate entities, and government organizations. When CERT issues an order or direction, the concerned entities are legally bound to comply by taking appropriate action, providing necessary information, or extending assistance as required. So, the key directives include time synchronization. So, all ICT system clocks must be synchronized within the Network Time Protocol (NTP) to ensure uniformity across systems. Then, log retention. So, all ICT systems, communication technology systems, must enable logs to be stored for a rolling period of 180 days within India. Then, point of contact. So, organizations must designate a specific point of contact to interface with CERT. Additional mandates for service providers has also been mentioned in those directions, that is, data centers, VPAs, cloud, and VPN providers must retain specified customer information for at least 5 years. They cannot delete it even after the cancellation or termination of service. So, the virtual asset ecosystem also I have to talk about, which means the providers of virtual asset services, exchanges, and custodian wallet services, as defined by the Ministry of Finance, must retain Know Your Customer (KYC) records for 5 years. Now, I have to talk about digital privacy and media ethics, which is a complex interplay in today's digital age, balancing freedom of the press with individual privacy rights has become increasingly challenging. So, the growth of data protection laws like the General Data Protection Regulation GDPR requires journalists to obtain consent and ensure data security and maintain transparency, posing both ethical and operational challenges. So, understanding how such laws affect journalism helps anticipate key issues like source protection, data sharing across borders, and the right to be forgotten. So, this understanding is crucial for developing responsible reporting practices. Now, what are the ethical challenges that surrounds reporting and interlinks with personal data? So, journalists must navigate ethical tensions or contradictions between the public's right to know and individuals' right to privacy. So, consent, potential harm, and the relevance of personal information are core considerations in this digital era. In order to assess how current media codes of ethics address all these ethical dilemmas and proposes improvements to support ethical journalism in a data sensitive world, I would like to recommend certain ways forward. Uh, those practical recommendations include helping journalists comply with privacy laws while upholding press freedom. Then, establishing ethical guidelines, clear guidelines, and the best practices for digital journalism. Then, offering evidence based suggestions to lawmakers to balance data protection with public interests. So ultimately, this discussion underscores the need for collaborative frameworks, clear standards or code of conduct for journalists, mutual accountability to ensure that media ethics and digital privacy can coexist in a rapidly evolving digital landscape. Now, digital privacy laws and journalistic practices, how these are interlinked. The rise of digital privacy laws, such as the General Data Protection Regulation in the European Union, has significantly influenced traditional journalism. So, a lot of research has been conducted which revealed that journalists face challenges in obtaining legal consent for publishing personal data, and they often struggle to balance privacy laws with the public's right to know. Uh, in order to further emphasize the growing need for transparency in data collection and processing, showcasing how privacy regulations are reshaping journalistic practices, I need to discuss also. So, reporting on sensitive data such as health records, sexual orientation, or criminal histories presents complex ethical challenges. So, the scholars, media scholars, stress upon the importance of minimizing harm and responsibly managing personal data, particularly when obtained through data breaches. Similarly, other scholars also highlight the tension between the public interest and the individual's right to privacy, urging the journalists to navigate this digital space with care, consent, and a strong ethical foundation. Now, to talk about media ethics and professional code of conduct, ethical guidelines and codes of conduct are crucial tools that will guide journalists in resolving privacy related dilemmas. And it is also found that journalists consider such factors such as public interest, individual impact, and accountability when facing ethical decisions in data driven journalism. Similarly, some media scholars also affirm that the relevance of ethical standards in guiding responsible reporting practices. So, the core principles such as objectivity, transparency, and confidentiality of the data sources help journalists handle sensitive subjects with care. Now, what are the different strategies for balancing journalism and data protection? To address this tension between data protection laws and journalistic freedom of expression or press freedom, media scholars, researchers propose several strategies. So, all these strategies include the first is anonymization or aggregating personal data using tools like differential privacy, implementing clear and transparent data handling policies, providing data ethics training for journalists. So, to conclude, I must say that cybersecurity and digital privacy are essential for journalists to protect themselves, their sources, and the integrity of their reporting. By understanding the risks and implementing the best practices outlined in this discussion, journalists can navigate the digital landscape safely and ethically. So, continuous learning and adaptation are crucial in the face of evolving threats. They have to stay informed about the latest security vulnerabilities and best practices and regularly review and update their security measures. Thank you very much.